All rise. The Orphans Court for Baltimore City is now in session. Judge Stephan Fogleman, Associate Judge presiding, please be seated.
Good morning.
Good morning.
All right, you're attending a session of the Orphans Court for Wednesday, November 19th, 2014. Please come forward when your case is called. Understand that there are sensitive electronic recording devices. Everything that you say will be picked up, including conversations near the back of the courtroom. So if you do want to have a confidential conversation, you may want to step outside for a moment. We're going to go ahead and call the first case. The estate of Denise Scott, estate number 101463. Morning. Ma'am, are you Bernice Scott?
Yes, that's correct.
All right. We have a court's motion to remove you as a personal representative for failure to file a first accounting. I understand you've spoken with our staff here and that you're prepared to go to the Register of Wills down the hall. Is that right?
I don't think so, Your Honor.
All right. Good morning. How you doing?
Good morning, Your Honor. Hassan Barnes, on behalf of Ms. Scott.
All right. I understand there was an audit request by the Register of Wills to require the distribution to the heirs, or?
Yes, Your Honor. We filed first accounting back in October 2014, and the clerk wanted documentation with the other two heirs, Ms. Natay Scott and Ms. Erica Richardson, waiving their interest in the property. But parties initially agreed to it, but changed their minds. So they wouldn't sign the waiver. As a result, we're here before you now. I talked to my client before the hearing, and now she's agreeable to adding her sisters both on the deed of the house. So I think the issue is resolved. So we were here last time because it wasn't filed. We filed it, and we needed more information.
Right. All right, is that the case? Is there anyone here who's objecting to the procedure requested by Mr. Barnes?
No.
All right, and ma'am, what's your name?
My name is Natay Scott.
All right, Ms. Scott. Natay Scott, you're the daughter of the decedent?
Yes.
Okay. And is Erica Richardson present?
Right.
Good morning, Ms. Richardson. Do you have any problems with the proposal that's made by Mr. Barnes?
No.
All right, then we'll go ahead and continue this matter. Well, we'll go ahead and dismiss the removal petition at this time. It's our own motion from the court. We'll go ahead and dismiss that, and the account will continue. I mean, the estate will continue under it. Ms. Scott. Bond remains the same.
I will file an amended administration, including both Ms. Richardson and Ms. Scott as co-owners of the property. That should be enough to resolve this thing.
Can you do that within 30 days?
Yeah, I can do it.
All right. So ordered. Thank you very much, Mr. Barnes.
Thank you.
Appreciate it. Thank you.
Thank you.
All right, the court is next going to call the estate of Nathan Gerber, estate number 105032. Good morning,
Good morning, Your Honor.
Mr. Renner.
Yes.
All right, and Mr. Gerber, you're here. Good morning. All right, I had you in here back in September, I believe. No?
No.
I remember this, yeah. Oh, no, different case. Sorry about that. All right, we are here today on a judicial probate determination. There is some question as to whether proof of publication has been made. Is that the case?
Your Honor, we haven't been appointed personal representative yet.
I thought there would still be some kind of notice as far as this hearing to go forward. And I don't think the file showed that notice, there's no receipt yet that notice had been made.
Yeah. Your Honor, we originally petitioned to, as an administrative matter, to have Mr. Gerber appointed personal representative. And we thought that was sufficient because we had the consent of all of the legatees and the heirs. And there was a codicil made to the will that appointed Mr. Gerber as personal representative. So I was sort of wondering myself why that hadn't happened yet. and that this was before your honor today.
All right, yeah, I mean, it sounds, I mean, it sounds like everything's wrapped up in the sense that even though there possibly are pages missing of the will.
There is an issue with the will, but as far as with respect to just appointing the personal representative, I think we have enough to get that accomplished without being before court. At least I thought.
All right, what are we talking about as far as bond? What do you think is appropriate?
Well, we have a waiver of bond, Your Honor, from all of the beneficiaries under the will and the heirs of the estate.
All right. Let me see. Mr. Bruce Gerber, what's your date of birth, sir?
12/2/51.
Right, you've never been convicted of a felony or any crime which would disqualify you from service in this regard. Is that right? All right. All right, I'm satisfied then. We'll go ahead and appoint Bruce Gerber as the personal representative of the estate of Nathan Gerber, estate number 105032. The personal representative will be excused from the necessity of posting bond in this matter due to the waivers having been signed by the interested parties. All right, thank you very much. Mr. Rayner,
Yes, sir.
do you want to go ahead and request this morning that the will be admitted to judicial probate?
I would, Your Honor.
All right, we're on the record in the estate of Nathan Gerber.
And Your Honor, while we're on the topic of the will,
Yeah.
with respect to the missing pages, the missing pages affect the disposition of 4 of 6 shares that were created under the residuary. There was a will that we were able to obtain that the seat signed in 1999 that disposed of. It very much looks like the 2006 will in many respects, and the residuary distributed those remaining 4 shares among Bruce Gerber, Martha Booker, Brian Gerber, and Michael Gerber, who coincidentally, Your Honor, are also heirs of the estate. So I guess I would ask that the court order that either those 4 shares are either distributed to those 4 individuals as legatees, or those 4 shares that are unaccounted for under the 2006 will are to be distributed to the heirs of the decedent. In this case, it happens to be, it would fall to the same individuals anyway, but I would just like to have some guidance of how to dispose of those 4 shares.
Well, I mean, I think that the former that you suggested is going ahead and distributing as legatees would be sufficient legally to accomplish the same purpose.
Okay.
So we'll go ahead and order that. We'll admit the will, the last will and testament of Nathan Gerber is admitted into judicial probate, and that is the will of February 7th, 2006.
Yes.
All right. With the ordered relief as requested.
Thank you.
And Mr. Hong has reminded me that it is a regular estate, so we can't have no bond at all, but we have to have nominal bond. And
Oh, of course.
so we'll go ahead and set nominal bond in this matter. And
Did we file a nominal bond? Typically.
I would think you would have. Yeah, I don't see any record of any bond being filed, but you can double check that for me.
Okay.
Oh, you do that, there it is, Hartford Fire. Yep. Nominal bond, you already have one in the amount of $25,000, and that'll control in this matter.
Thank you.
Yep, thank you very much.
Thank you, Your Honor.
All right, we'll go ahead and call the estate of Mary Elizabeth Berger, estate number 90932. Good morning, sir.
Larry Kaplan.
Good morning, Mr. Kaplan. Good morning, Ms. Harkleroad.
Your Honor, I'm entering my appearance for Henry. If I may stand up.
All right. All right, we have an issue here. It was a petition to remove a personal representative filed by your client, Mr. Kaplan. I understand we received some paperwork from him after the hearing indicating that he was not able to be here last time.
That's correct. He was here this morning with counsel. We believe we worked out a resolution. He had some medical issues last time, but he prevented him from being here, and the court just granted his motion for reconsideration.
Right.
And set today's hearing on his motion. And I think there's also a motion filed by the personal representative to allow her to go forward and sell the property. I think we've reached a global resolution, at least for now.
All right.
And we have put that in writing. There's a number of details here. The parties have signed, my client has signed, and the personal representative has signed. We'd like to enter this into the record.
Be happy to, yeah. All right, Ms. Harkleroad, well, I'll take a look at it. Ms. Harkleroad, the two of you came to this agreement?
To this agreement?
Right.
Yes, sir.
All right, and
Part of the agreement is that Mr. Berger Jr. will involve
all right, and then there are several conditions, 6 total conditions, including allowing Mr. Berger access into the property to be able to keep his father's service medal if it's located. And the remains of Ms. Berger are going to be shared. Okay, and in return, Mr. Berger is going to endorse your proceeding in a timely manner with the disposition of the property.
Yes, sir.
And he also agrees to withdraw his petition to remove the PR.
That's correct.
And there's a couple of other personal property distribution issues resolved. All right, the court will receive the exhibit as joint exhibit 1 in the estate of Mary Elizabeth Berger. We'll go ahead and, for housekeeping purposes, we'll go ahead and grant your motion to sell the properties subject to joint exhibit 1, which is the settlement agreement entered into today by Ms. Rossman and Mr. Berger. All right, is that fair? That's what we'll do? We'll go ahead and incorporate the settlement agreement that the two of you signed today. I appreciate you working it out. It's better to have loved ones and family members be able to resolve these issues without the court's involvement. All right?
Thank you.
All right, thank you. Anything else?
That's it.
All right. You'll have a nice day. All right, at this time, the court will call the estate of Vermal Williamson, 103-641. All right, it's now 10:28 a.m. This hearing is scheduled today at 10 a.m., November 19, 2014. Court's motion to remove the personal representative for failure to file an information report and a court's motion for contempt. Jemelesh Jackson has not responded and has not appeared, the personal representative. Court will go ahead and remove Jemelesh Jackson as the personal representative of the estate of Vermal Williamson, estate number 103-641. We'll find Jemelesh Jackson in contempt. And that'll conclude that matter.
Okay. Please read the results of court. Right.
Court's next case is the estate of Teresa E. McCormick, estate number 100417. Enjoying all the excitement in the hall.
Fucking 18, watch out. See your fucking self enough. Fucking talking to you, I got the fucking pull out.
Are you getting all that, Ariel?
I got it.
All right. All right, we're back on the estate of Teresa E. McCormick, estate number 100417. All right, good morning, sir. What's your name?
Michael McCormick.
Mr. Michael McCormick, you filed this petition to appoint yourself as the substitute personal representative. Isn't that right?
Yes, sir.
What is your middle initial, Mr. McCormick?
8,
What's your date of birth?
3/24, 1955.
3/24/55. Okay. And your petition indicates that the former personal representative, Flossie Leitner, passed away. All right. What was her relation to you? Your aunt. Okay. And you are now, that leaves you the only heir?
First representative.
All right. And again, you have no idea of the whereabouts of Ellis Curry, the father of the decedent? All right. And the mother of the decedent, Flossie Leitner, is now deceased. All right. So do you know of any other interested parties to this action? All right. Have you ever been convicted of a felony or anything that would disqualify you from service in this regard? Okay.
Middle name?
What's your name, sir?
A.
The name.
About
How do you spell that?
ABOAT.
The court is satisfied. We'll go ahead and grant your petition, Mr. McCormick. The court will appoint Michael Avant McCormick as the personal representative of the estate of Teresa E. McCormick, estate number 100417. You'll be excused from the necessity of posting bond in this matter because it's a small estate. All right, you may, we can get you an order quickly, which we should be able to do this morning. You should stop by the Register of Wills in room 346 and bring that to them. All right? All right, thank you, Mr. McCourt. Your motion is granted, and we should have some paperwork for you in 10 or 15 minutes tops. Yep, thank you very much.
Thank you.
All right, at this time, the court will call the matter of Kashia R. Reese.
Good morning, Your Honor. Paul Draper, I'm the court-appointed guardian of Kashia R. Reese.
Yes, good morning, Mr.
This is
Draper.
Ms. Reese herself.
Good morning, Ms. Reese. How are you doing? Good. We're here today, Mr. Draper, on her petition for withdrawal of funds.
That's correct, Your Honor. I just want to get a few preliminary backgrounds because I think we may be able to get this whole guardianship matter concluded. This matter initially started up in August of 2012. I was initially appointed in 2012, and then my appointment was rescinded, I think inadvertently by another court order. However, the bank had already in the interim had designated me as guardian on the account, but never changed the address. When that was brought to our attention in March of this year, I was reappointed by this court as the guardian. Unfortunately, in the intervening period, Ms. Reese actually became of age. She became of age in 2013. So there was actually no need for guardianship whatsoever to be reappointed at that time. So at this time, Your Honor, we have been appointed guardian. We would just, instead of requesting that withdrawal funds, we would just like to request that the guardianship be terminated and that our appointment be terminated and we be relieved of any requirement of following an information report, inventory, or accounting for this, because I don't think there's going to be any need to account for any funds in regards to this. The only other matter I had brought to Mrs. Reese's attention is that her mother had been actually initially removed because there were funds not accounted for. There was a problem with debt with the bank managing the account, Wells Fargo. I've been informed of her rights because she has rights to actually, since her disability ended within 3 years, so the day before her birthday, that she could institute an action against the bank. However, I did inform her too, if she did wish to do such an action, it would probably bring her mother in as a co-defendant, and that's how we would do that. But I just wanted the court to realize that we've informed her of her rights to proceed. If she would like to proceed forward with that action, that we cannot proceed forward on her behalf, but that we would request that this guardianship be terminated. Based on our records, there have been no funds removed from that account. Nominal interest has been accounted for from the guardian's prior appointment to the present. There's not been one money's missing.
What's the exact balance, if you know?
The exact
40,
balance,
30,
as we know of, by the 15th of this month, if she should get cents, would be $4,040.45.
40, 40, 45.
Yep.
Okay. All right, Ms. Reese, Mr. Draper has explained to you effectively what happened and the fact that you do have a legal right to pursue an action possibly against the guardian or prior guardian in this matter. You also, he's probably explained to you that if you get a judgment against somebody, that doesn't mean you get the money automatically. You still have to collect it after that, right? Are you in college now? Where are you going? Congratulations. Are you a freshman, sophomore?
Freshman.
That's exciting. So it's your first semester there.
Yes.
All right, well, we'll certainly, I wish there was more here for you to continue your studies, but we'll certainly release the $4,040.45 at this time. We'll pursue it to the petition for withdrawal. That's granted. Based on arguments from counsel, Mr. Draper, we will indeed go ahead and terminate the guardianship as well in this matter and remove the appointment of you, Mr. Draper, in this matter. Is there anything else the court can do to clean up these loose ends?
Not in this regard, Your Honor.
All right.
Thank you very much.
Good luck to you, Ms. Reese. Best of luck. And Mr. Draper, thank you again. I have one more file left on my desk here, and so I'm assuming you're here on the estate of Charles E. Hayes III.
That's correct.
All right. You are Mr. Sykes?
Yes, I am.
All right, come on up, Mr. Sykes. Additionally, we have an order here for Mr. Michael McCormick. Just give us a couple more minutes, and we'll get you a copy of that to take with you. But I have signed the order, Mr. McCormick.
Okay, thank you.
All right, Mr. Sykes, you're joined this morning by who?
This is Barry Robinson. He's one of the heirs.
He's one of the 13 first cousins.
That's correct.
How are you doing, sir?
Good, sir.
All right. So bring me up to speed here. First of all, has there been any notice or publication in this matter?
Yes, there has.
Okay. For the weeks leading up to this hearing?
Right.
Okay, as pursuant.
In order to allow the time, and I believe the register ordered the publication.
Okay, but you're telling me that, right, the elements of 9-112 have been met in that regard. Great. Then we'll go ahead and proceed today. Mr. Sykes, you're here on a petition for distribution. You've listed the 13 first cousins and then 4 first cousins once removed as shown by your due diligence in this matter.
That's correct.
All right, so are you proposing to distribute the balance of the estate to the 13 first cousins?
And, well, the first cousins, once removed, are children of deceased first cousins. So I'm proposing to distribute to all of those parties.
All right, so all 17 of the interested parties.
That's right.
All right. All right, you don't have any breakdown as far as the sums that each would receive, do you?
I do not, since I couldn't do that until there was a final determination of how many shares there would be and who they would be distributed to. And there's also still a couple of other matters that need to be dealt with. I mean, I still have to file a petition for fees, and there is one more tax return that will need to be filed.
All right. So today specifically, you're petitioning to evenly distribute the remains of the estate to the 17 people.
Well, the first cousins, once removed, the children of the deceased there's 2 in each case, so they would actually be getting half shares.
All right, and who are they? Just so I have that. If you know.
Well, you've got me on that.
That's all right. Do you want to go ahead and send the court correspondence, just
I can
further
do that.
explain the situation? Yeah, I just want to make sure we get it right.
Okay.
The court will go ahead and order distribution pursuant to the law of the interested parties. And if you just want to just send correspondence to us and attach it, just so I understand, because from my bench notes, I see 13 first cousins and 4 first cousins once removed. So of course I'm saying, hey, let's just give it to the 13 first cousins.
Right.
But it's not that simple. They all have to be alive, et cetera, et cetera. So go ahead and give me, just go ahead and get an exhibit over here. We'll go ahead and sign an order. In fact, if you want to prepare the order, that's the other thought in the matter. The court will sign that. Is that something you want?
I can attempt to do that.
And you can get some help from our folks here at the court as far as vernacular, things like that. That or an exhibit, and then attached to a letter, and that'll assist us in preparing the order for distribution.
Okay.
All right?
Will do.
All right, do you have any questions, sir?
No.
All right, thank you both. Thank you, Mr. Sykes. All right, have a great day. All right, we've got that order for you, Mr. McCormick.
All rise. This court for Baltimore City is adjourned.
Oh.